law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide the information and resources that'll help you decide whether or not you need or want to contact a lawyer. Perhaps you'll determine that you can handle some issues yourself. If you do need additional outside professional counsel, you'll be better prepared, and so will the professional you select. Of course, our goal always is to save you time and money and achieve the best possible results. We continue also to welcome and thank the Bazar and Associates law firm in East Providence, and want to welcome again David Bazar. Thank you, Counselor. So today, slip and fall. It's one of the 5, I guess, most common types of personal injuries, with med malpractice and vehicles and boats and wrongful death. Well, with millions of lawsuits every year, we thought this would be a good topic to tackle. And considering there are so many facets to it, whether it's brain injuries and scarring and pain and suffering and all of these details, there certainly are many issues to cover, including how to handle a case, the wisdom in doing it yourself, or who is at fault, or what's reasonable, what you should do to select a lawyer. Lots to cover. We thought that considering this time of the year, it might be a good idea to discuss the issue of slip and fall relative to snowfall and then the eventual black ice. So, David, give us a little bit of a tutorial about what personal injury law and slip and fall is. How does that fall into the play?
You actually started out with personal injuries, and they can come in a lot of different forms. Auto accidents, probably one of the most common. Medical malpractice you mentioned, which would be medical negligence, something that a medical professional does that deviates from the standard of care that one would expect. Products liability is another area where you have personal injury cases where a product is defective and causes an injury. Slip and falls, which are generally also called premises liability cases. And what those generally involved is the owner or occupier of land somehow has done something that's negligent, that hasn't met the standard of care of either the homeowner or the merchant or the landowner, and as a result of a defect that exists that they had an opportunity to fix, someone is injured. So in a nutshell, it's a negligence premises liability case.
So there are lots of wrinkles to that, and I can think of several scenarios that have just recently occurred because we had a significant heavy snowstorm, wet heavy snowstorm, which ended up later on with it being shoveled and then turning into black ice. So if you have a neighbor on your property, you've shoveled, there's some black ice, it's dark, he slips and falls, you shoveled your property, what happens?
Well, different states have different rules. And there's also probably different rules for homeowners, residences, and commercial owners of land and merchants, because you have the difference in what the person who's on the property's status is. And by that I mean it's the old difference between a trespasser, an invitee, or a licensee. Someone who's invited on the property has more of a expectation of being safe than a trespasser on property, for example. And at different times in the course of the evolution of law, that's changed a little bit in Rhode Island, for example, where they abrogated the difference at one point in time between those statuses and then reinstated them. So we'll just take it one step at a time and do some evaluation.
So I mentioned a neighbor. Maybe he was invited, but he's a neighbor, and neighbors do end up sometimes in your property, whether they weren't specifically on that day invited or not, but what happens then?
So you mentioned a neighbor, so since you said neighbor, I'm going to take it to be a residential situation. And part of the analysis of the status of somebody on the property also involves, for many courts, the reasonable expectation that that person might be on the property. So if you invited a neighbor over for dinner, I'm going to say that's an invitee. And they actually have an invitation, so why not? So you've invited them over for dinner. It had snowed out. You know they're coming. You cleared the snow. It got warm, and then it got cold, and it formed black ice. And you knew that that could happen or would have happened, and you didn't do anything about it, and you know they're coming. There may be liability in that instance for you to the neighbor for not sanding the black ice. Whether or not you knew it actually existed, it's whether you knew it existed or should have known that it existed, because you knew you shoveled, you knew it was cold, got warm, and got cold again, and you didn't sand, you might have some liability to that neighbor. As opposed to you're not home, you shovel, you leave, and you see the commercial with the people saying, should we rob that house? And there's a bell that has a camera or something. Yeah, I wouldn't do that if I were you. Well, the person who's not invited, who's actually a thief, is approaching your property, and he slips and falls, and he now wants to sue you. Well, number one, what standard of care did you violate in taking care of your property, because you weren't there, you had left, and you weren't expecting anybody to be there. So there might be a different result in that kind of case.
Someone's delivering from FedEx, UPS, Amazon, flowers.
Licensing. Yeah, someone who you didn't invite but is reasonably expected to be on the property, there's probably a duty of care to that person. And you have to do, we're still in residential, what any reasonable residential person would do when caring for their property. So if you shovel and you know you're going away and it was cold and it might get warm, and you should put salt or sand out and make sure you take some precaution in case something like that happens. So it's what's reasonable under the circumstances.
One more caveat to that, or one other little wrinkle. So you've shoveled, you've sanded, the city came by with its plow, put more snow in, you've been out and away working. Meanwhile, someone else comes in, there's the scenario, someone slips and falls. What's reasonable? You've done your due diligence, you've done what you could reasonably take care of. How were you, A, to know that someone was going to backfill what you had done? Right. How can you deal with that? Yeah,
that's probably a case that's defensible, because you did what any reasonable, ordinary person in your situation would do. You treated this property, you cleaned the snow, you sanded it, you did what you had to do, and you left and you went to work. You're not an insurer that nothing's going to happen on your property. You're just a reasonable person trying to do the right thing, and if you do what any reasonable person would do, there shouldn't be negligence in that thing, in that situation, because you didn't really violate, you didn't breach the duty that you owed to whoever might be on that property, because you used reasonable care in taking care of your property.
Okay. Now, suppose you are a landlord and you have a contract or a lease with your tenant, which says it's the tenant's responsibility to take out the trash, shovel the walkway, because you must shovel your walkway and your stairs, and that's agreed upon. The contract is, the lease is signed. He doesn't, and something happens.
Who does it happen to?
It happens to one of the neighbors. First case scenario, and second, someone's delivering something. So you have it in writing. If you're the landlord, how do you distribute that blame?
There's a couple of issues. We're still going to be talking residential property.
Okay.
And given that it's residential property, my argument would be that the landlord can't delegate his duty to somebody else. Now, he can have a contract with the tenant, and as a result of the contract, he can sue the tenant for indemnification, which means, wait, you were contracted to do this for me, you didn't do it, I'm being held liable, so anything I may have to pay, you have to pay me back, because it was your responsibility. And of course, the only way a landlord's really going to protect himself or herself in that situation is to require insurance. So first and foremost, anyone who owns property should have insurance, liability insurance, in their own right, their own insurance. But they should also require, in a situation where they've rented their single-family home to a tenant who they've assigned in the lease all that responsibility for, they should require the tenant to have insurance that names the landlord is a named insured on their liability policy.
Good to know. Good prophylactically, too. So we discussed the landlord and tenant. How about if it's in a business, you own the property, you have tenants who are various businesses, and you've also, as the owner of that property, contracted with a company to make sure that everything is plowed. They usually come at 7:30, they came at 10:30, and something happens.
Right.
Who's to blame and who gets sued first, second, and third?
So in that situation, you are probably going to see the owner of the property get sued, the tenant get sued, and the maintenance company get sued. And as between the three defendants, who's responsible as between the landlord and the tenant will also be found in the lease, in the commercial lease. And there's a little bit more forgiveness to the owner of the property in a commercial setting, at least in Rhode Island, in terms of liability to the third party, the delivery person or the invited business guest of the tenant, than there is in the residential setting. But again, you want to look to the terms of the lease. So if somebody goes into Stop and Shop or Whole Foods, or in the old days, Allmax, and slip and fall, they're probably looking at the tenant in that situation as opposed to the landlord, because usually inside the store itself, the lease is going to require the tenant, the commercial tenant, to have the insurance. If it happens outside in the parking lot, it becomes more of an issue as to what the lease requires, especially in a shopping plaza or a mall situation. Is it the mall owner, the shopping plaza owner, who has the outside and the tenants have the inside? Or is there some shared arrangement? So as a lawyer, you need to get the lease when it happens outside in particular, and certainly you'd want to look at it in an indoor situation anyway. And then the third part that you rolled into that is it happened outside because of snow or ice or whatever in the parking lot, and there's a company that's been hired to do the parking lot and they didn't show up because a piece of equipment broke or whatever their excuse might be. As the owner of the property who contracted with that maintenance company, I would want to make sure that they had insurance, because it's their negligence that caused the injury, because I hired them to do a job. Now, if I see that they haven't come, I should probably go out and do what I can in the interim, but certainly that company that was hired should have insurance, and if there's a written agreement with them, they should be primarily liable for not doing their job.
And earlier you had mentioned the idea of what's reasonable, or what someone has done, should have known to do. So if the landlord of, whether it's a commercial property, owner of a commercial property or residents, they've done what they thought was right, let's contract with someone to make sure that they take care of it, and something else happens. There's another snowstorm 3 hours later, but they are only contracted to have someone come once, whatever those variables are. You can come back and say to that tenant, I assume, you should have known that you had to call that contractor again and make sure he came again. If something happens that second time, I mean, those are little wrinkles, but those little wrinkles are some of the things that can cause great problems.
Those little wrinkles are really the issues that make each lawsuit unique and each claim unique, because you have to know exactly what happened and how it happened and what the deal was. So if you have the commercially hired maintenance company that's supposed to do the snow plowing, and the contract says, I only want them to come once, and they come once and they did it, and it continued to snow and they didn't come back because the contract doesn't require them to come back, did they breach their duty? And did you do everything you could do as either the owner or the tenant to make sure everything was taken care of? Well, most commercial situations where you have a retail shop or a bank or something where you expect people to come, you hire somebody to do that, and you tell them you come as often as is necessary to keep the premises safe. And therefore, if they don't do that, you point right back to the maintenance company that you hired and say, you didn't do your job, if they didn't do their job.
So, of course, as you're saying, you're trying to cover as many contingency as you possibly can. It's been only a few minutes. The snow has happened again. How much could they really account for to come back? Is there a regular procedure of examining how safe it is? Did they do a good job? Did they come back a second time? Sounds like that's an awful lot of backfilling once you have someone who's slipped and fallen.
There's, to me, more difficulty for the claimant for a claim where they slip and fall while it's still snowing. Because what can the landlord, tenant, or maintenance company really do other than plow what was there at the time, sand and salt as they can, and try to do all of those things that they can. But while it's still coming down, again, you're not an insurer. You can't make sure that there's no possibility that there's not going to be a slippery area because it's still coming down. And the law in most states gives some protection for that. You have to have reasonable time to clear after the storm ends, and you want to take whatever reasonable precautions you can while it's going on. But if you do that, what duty have you breached to the person who got injured?
Fair enough. As you've been explaining these possible details and wrinkles that could change the scenario of who's at fault and when. So for the person who has fallen, they go to a doctor. Maybe they went to a hospital, and seems like they're certainly going to live. It doesn't seem like there's terrible injury here. The person who is responsible, say the landlord says, I'll pay that doctor's bill, that hospital bill. Should it be enough to just put an end to the story? Sometimes we say someone can handle it themselves. Would that seem pretty cut and dry, that you should say, no, they don't really need to call a lawyer? How do you know?
The description that I understood that you gave is minor injury, had to go to an emergency room or something to get checked out, didn't have any other treatment beyond that, and I'm fine. Is that the scenario?
Fair enough.
Okay. So in a scenario like that, most insurance policies would have MedPay, which is insurance that covers the medical payments necessary because of a slip and fall, regardless of whether or not there's any fault. And so you can submit the claim, your medical bill should get paid, and that could be the end of the story. If there really was so little injury that it's not worth pursuing a claim for the pain and suffering that you may have incurred. But if the injury goes beyond that and you have some pain that continues and requires further treatment, at that point in time, you're best off hiring an attorney who can make sure that all of the issues that you're suffering from are compensated for.
So you always say it matters that you handle things as quickly as possible. So obviously the first thing is you're going to go to a doctor or the hospital, whatever you need to do. I've read somewhere that it needs to be taken care of in the first 72 hours because then you might have wrenched your neck for something else or whatever.
Right.
So at what point after an accident do they call you or call a lawyer to say, just want to put you on notice, thus and such happened. I don't know if this is, they're going to stitch up my whatever and I'll go on to work tomorrow or maybe a day out. What do you say to them? How do you get to evaluate that? What do you counsel them?
Let's start at the place of the injury.
Okay.
You fell in a parking lot outside. That's the snow, ice, whatever. It's not snowing out. It snowed the day before, 2 days before. It wasn't treated. There's clearly some negligence here. And you hurt yourself pretty badly. It's hard to remember some things, but some things you need to know, or you probably should think about is, and I'm too old myself to know this, but you have a camera usually in your pocket, a phone, maybe some pictures of where you fell and what happened, or some witnesses. Get the names of people who saw it, report it to the place where it happened, make sure they know, and try to document as much as you can as to exactly what happened and why it happened and what precautions you took to avoid it, so that you can preserve the evidence. And then you're going to get taken away by an ambulance to wherever you go for treatment. So yes, getting yourself better, as we say, and making sure you're okay, first instance. But if there's someone with someone else who falls, maybe they can be the one to keep, the presence of mind to make sure they gather as much evidence as they can to show what happened, and then bring all that to an attorney.
And so when someone calls you, if it seemed like a simple slip and fall and it wasn't anything that was serious, do you not only have to judge whether or not there is enough value to take this to court? Because maybe it simply is have the guy write the check, finish off what you need to for occupational rehab if you need a little of that. And do you also have to ask about what part of might there be of your carelessness in why you fell? I mean, do you go through those things on the phone? Is that something someone should reasonably expect, or should we say you have to set up a meeting, we have to go through all this? How does that play out,
Well,
David?
generally, I think to go through everything carefully, there should be an appointment and a discussion as to all of those areas of a claim which are important. You mentioned 3 of them. One of them is damages. If there aren't enough damages, the attorney, depending on the type of case, well, for any case, isn't going to want to take that case. What an attorney might think about is what's enough damages will depend on the type of case it is. Again, we're talking about slip and falls, but the amount of damages required to have an interest for an attorney to take a slip and fall is much different than the amount of damages required for a medical malpractice case. And the reason for that is the expense of the different types of suits you would be bringing. In a slip and fall case, if you came into an attorney and you had some significant injury but not, you called it life-threatening, we'll say permanent disability or really debilitating for a long period of time, but just, really injury that is significant, that's going to impact your activities of daily living for months, you might be willing to take that case as a slip and fall case if someone comes in and says, look, here's pictures of where I fell, look at all the untreated snow, look at the weather reports. It hadn't snowed for 2 days. They had plenty of time to cure the defect. They didn't do it. There's foot marks across most of the snow because people have been trampling back and forth in the snow. And I have 4 witnesses who saw what happened, and I didn't do anything wrong. I was just walking along, and boom, I went down. So that might be a case where an attorney would take with 2 or 3 or 4 months of disability. Whereas that's all you had for a medical malpractice case, an attorney might not take that type of case.
So when you say might take that with 2 or 3 months disability, meaning the word settle?
Well, you take the case, you always try to settle a case, but many cases go to suit. Many cases that go to suit resolve after a mediation or an arbitration, as we've talked about before, alternative dispute resolution. But there are cases that don't settle, and so if an attorney is going to take a case, it has to be good enough for the attorney to want to take it all the way through to trial if that's what needs to happen.
So if someone has not yet gone to a doctor and gone through gone to a doctor but not gone through all of the stages, which might mean that they might have had a more serious head injury than they quite understood. You're not a doctor. If someone's talking to you, you're not a doctor, you are a lawyer. Would you be able to say to them, well, you might have a case, I'm not sure, let's see how this plays out and how you feel inside of 3 weeks, 1 month? When do you file a suit? How do you know if you should?
Well, first of all, to answer the first question, sometimes you don't know how the treatment's going to play out. So you might say, yeah, we'll open up a file, we'll take a look at it, and you want to get the medical records in and see how somebody's tracking and what their recovery is going to be like. And so as far as that goes, you might take a case you're not 100% sure of up front to make sure that if it does become something that's worthwhile pursuing, it's being done the right way and you're gathering up all the evidence that you need to get right at the beginning. As far as putting in suit, you wouldn't put a case in suit for a while on that type of case. Especially if they're still treating and you don't know what the outcome's going to be because you want to be able to try to settle it first. There are some cases, though, where you need to put them in suit right away because there may be catastrophic damages, there may be evidence that you need to preserve. It depends on what happened, where it happened, and how it happened, and what you need to do to preserve evidence. So some cases do need to go into suit much sooner than others just to preserve evidence.
And what about the element of pain and suffering? So someone might honestly think this is just a minor issue, but as it plays out, that pain may linger. It may trigger some other issues. I thought I was going to work 2 days. It's 2 weeks. It's 2 months. You can't know that at the outset. So how do you determine how you're going to, which buttons you're going to press when? Try to settle versus let's let this go much longer to see how much pain and suffering you really are going to endure, because we don't know yet.
Right. And I almost always tell my clients we can't settle the case until we know what the outcome is. So when you settle, you sign a release. And when you sign the release, you're giving up your rights to make any further claims for the same injury. So whatever that number on the release is that you're settling for is all you're going to get. And I'll often explain to my clients what the release means, and then sometimes say, so what this means is if your right arm is no longer useful tomorrow, the day after you sign the release, even though you were treating for your left arm the whole time, we can't go back and get more money for the right arm because we settled. So until we know that you've had a complete recovery, or we know exactly what your recovery is going to be, I wouldn't settle a case. I'd rather see that case go into suit and see what happens than settle too early.
So it sounds like there is reason to let it play out a little bit longer rather than just rushing to make a quick settlement. Correct. In those cases.
Right.
So David, you are a lawyer. If you were shopping for a lawyer to handle something like a slip and fall case, what would you look for in a lawyer? Someone who's made quick, immediate settlements, the amount of settlements, the amount of trials they've got. How do you evaluate what a successful lawyer, say in another state, would be, how they would handle a case? How would you evaluate it?
Well, the evaluation is the same as hiring a lawyer to do anything. First and foremost, do they have experience in the area that you're hiring them for? So if the person has experience in a personal injury case, is going to handle your case professionally and ethically, and you're comfortable with that person, that's the second part of it. You want to make sure, I would want to hire someone who I'm comfortable working with, someone I like, someone I trust, someone I think will do a good job for me and has my interests at heart. That's part of the evaluation I would do. So I would make an appointment with someone. Oftentimes I would do it myself based on recommendations from other people I know. Who have you used? Who do you know who's been in this situation? How did they like their attorney? Maybe make an appointment with that attorney and sit with them face to face and see what I thought of them.
Does it ever make sense to talk to a couple of lawyers? Not shop around, but maybe I do mean that. If you are talking about how much experience they've had, that's one thing. Maybe that's a black and white answer when you ask it. But in terms of how comfortable I might feel, I might not know that until I have a conversation with someone. Should I have several conversations with different lawyers first?
If you feel it's necessary, if you meet with someone and you're not sure, I don't really know if I click with this guy, I don't really know if I like this guy, go see someone else or girl.
Good to know.
Yeah.
Well, we've certainly covered various elements of what a slip and fall case might be. I think that we might have others coming up in the near future. We hope that you'll stay tuned to The Law Matters, because it certainly does matter to you. Thank you for tuning in.